Other news, the Marquise Jones federal civil rights trial is expected to go to the jury today after 6 days of testimony.
Now, at question is where Jones' there's civil rights violated when he was fatally shot by an off-duty San Antonio police officer. The officer was working security at a Northeast Side restaurant. This was back in February of 2014.
Paul Venema joins us now. So much to talk about in this case. Paul, now you say testimony has included both current police chief William McManus and former SAPD chief Al Ortiz.
Right. The police chief himself, McManus, was there. He was there last week as a plaintiff's witness for the Jones family. He was recalled yesterday by the city, so he made 2 appearances. Yesterday, former police chief Albert Ortiz was there. He's now since retired, and he's considered an expert witness called by the city.
Is that unusual to have a witness like McManus called by both sides?
Yeah, it is. I would think so, because obviously they didn't get what they wanted out of him during the first time around. And so they can have that opportunity, and the city took advantage of that, of his position as chief of police. And his testimony essentially was the same when he testified for either side, and that simply was that this shooting was justified. He stuck by that when he was on the direct examination by the plaintiff, as well as yesterday.
Paul, you and I were chatting before the newscast. You said the main question here to answer is whether Marquise Jones had a gun. Was a gun found at the scene?
There was a gun found at the scene. It was 25 feet, I think, was the testimony away from Jones' body. So there was a gun found. Whether or not he had the gun, whether he was attempting to use it, that's something that the jury is going to have to resolve. And therein lies the big question here, because some witnesses have said yes, he had a gun. Some said no, he didn't have a gun. Others said, well, yes, he did, and then they changed their testimony, changed their mind rather in their statement. So there's a bit of confusion. That's going to be the most difficult thing for the jury to resolve, simply because that therein lies whether or not his civil rights were violated.
Right.
If he's unarmed, obviously a civil rights violation.
We hear jurors. We think 12. There's 8 jurors in this one.
And that's up to both sides if they can agree. And they agreed they wanted 8, and this is in federal court, and they agreed to have 8 jurors. And it's usually it will be a unanimous verdict. But both sides can agree that they can go with just a majority on that, which would be 6 jurors voting in favor. So there's a lot at play here. All of this is going to be resolved when the jury charge is read to the jury. This morning we'll have closing arguments from both sides. Each side's been given 90 minutes by the judge, and following that, the official jury charge, which is the law that the jury applies the law to the testimony, and that's how they arrive at their verdict.
One of the questions we always like to discuss with you, Paul, is how long do you think this jury will be out, and do you think this federal jury will be sequestered?
Well, how long the jury's going to be out is like how long is a piece of string, you know? I mean,
it just depends.
Yeah.
But you also told me that in cases like this, where we've got federal cases, 1 day of testimony equals at least 1 hour of deliberations.
Yeah, kind of a rule of thumb. They try to give somewhat of an idea how long they're going to be deliberating. They usually consider 1 hour of testimony and a day's worth of deliberation. So, as far as sequestering, that'll be a decision that'll be made down the road. And usually, when a jury is sequestered, it has to be because both sides will not agree to let them go home for the evening and come back. If both sides say it's okay for them to go home and resume their deliberations in the morning, they'll come back.
And real quick, have they already decided that they can reach their verdict not unanimously, or does that happen if they can't reach it unanimously?
No. They will have to make that call, and that will be made by, it will be in the jury charge, which the jury charge is the judge drafts the charge, both sides have some input, and they'll make that call before the jury charge is read to the jury.
I assume you're heading to court right now.
We're going to take a look.
All right, Paul, thank you.
All right. Good.